Good evening, folks. I'm looking on one piece of paper I just had. Good evening, welcome to the Scituate Zoning Board of Appeals meeting, Thursday, August 21st, 2025. I will make a motion, entertain a motion to accept the agenda, or I'll make a motion to accept the agenda with comments. Do we have, I want to change the order tonight and do our second application first. Are we ready to do that? Jeff Century Schecter, are you ready to go?
We're here, but Jeff Lacey's handling.
Okay.
I don't see him yet. I saw him 20 minutes ago.
He messaged me too, and asked to change it.
Go
Is that right? Yeah. All right then. Then we will not change the order. So I'll accept a motion to approve the agenda as submitted.
Oh, second.
All in favor? Aye. All right, so on our first application, this is a continuance from July 17, 2025 hearing on the matter of 3A Service Station Corporation, 32 Fairview Ave, Scituate, on behalf of Edward Scassoloni and the Edward Scassoloni Trust, appeals the notice of violation dated April 1, 2025, pursuant to Mass General Law, Chapter 40A, Section 8, and Section 920, of the Town of Scituate zoning bylaw, and or request a Section 6 finding, special permit pursuant to Mass General Law, Chapter 40, Section 6, and Section 820 of the Town of Scituate zoning bylaw. Subject property is located at 781 Chief Justice Cushing Highway. Before we jump into it, I just want to set a few ground rules. We're here tonight to discuss the appeal of the violation notice issued on April 1st, 2025 and amended on May 6th. We will not be discussing anything outside of this topic, includes proposed or theoretical uses such as coffee shops. The building department received a request for a zoning determination regarding the food and beverage retail use at this site. As this topic was not mentioned in the violation notice, it will not be part of this hearing. It's my opinion that a separate hearing should be held for any proposed, alleged, or pre-existing uses not mentioned in the violation notice. I have a brief, you want to kick it off?
Yes, thank you. Good evening, Chair Carter. Good evening, everyone. My name is Adam Brodsky. I'm a local land use and environmental lawyer, and I represent 3A Service Station Corporation, David Westman, who's sitting beside me, is the president of 3A, and 3A leases the property from the Edward Scarzaloni Trust and Mr. Scarzaloni individually, they're separate parcels, and Mr. Scarzaloni is also present in the room. As you will recall, this site has been used as an auto service station since the early 1930s, and that use predates the adoption of zoning in Scituate. And this property has a long history of additional uses, separate and distinct from the auto service station, which included, among other things, the operation of a tow yard, and also, we've actually found out the woodlot operation. While the woodlot operation has been operating since approximately 2016, when we asserted that the towing operation ceased, we've discovered, and Mr. Scarzaloni provided to us photographs of a woodlot operation in that very same vicinity. Those photographs are from 1983, and I did provide those to the zoning board yesterday. I do have hard copies if you haven't received electronic copies, which I can hand out to you. And included in that package are also photographs during Scarzaloni's many years of operation of this property, showing the storage of vehicles, and that's distinct and separate from the auto service station operation, and in fact also distinct from the tow yard operation. With respect to the violation, one violation you may recall was the storage of boats, and immediately upon receiving the notice of violation from Mr. Vogel, those were removed from property. Again, a demonstration by 3A of complying with the zoning bylaw. But the vehicles that are presently stored on the property, again, separate and distinct from the auto repair operation, are a continuation of vehicle storage, which has been going on unchecked for decades. Those are associated with Northern Oaks landscaping, and as I mentioned, the storage of the vehicles is a continuation of the pre-existing use. However, Northern Oak was also using the property to store landscaping materials, and Mr. Westman, on behalf of 3A, did request that Northern Oaks remove those landscaping materials. I believe they have been removed. There may have been some material that I think was placed there last night or the night before mistakenly, which will be removed. And so with respect to that operation, going forward, we're only seeking, again, the continuation of the use of that property for storage of vehicles. I think there is some confusion because the property is also being used on a temporary basis by PA Landers for the storage of materials associated with the MassDOT project on Henry Turner Bailey Road relating to the signalization and the sidewalk. Chair Karchik asked me, do we know when that project is going to end? And we don't know the answer. That's a temporary use. Those materials will be removed at the conclusion of that project. We candidly stated in our appeal at the time, and again, this was filed months ago, that we believe that the woodlot operation constituted a change in use which required authorization under the zoning bylaw. However, as I've told you, I've learned that in fact there was a woodlot operation there at one period of time. It's difficult, and I've also admitted this, to actually document the timeframes for all of these activities. There's no doubt that, again, for decades, there have been other uses on this property that have been open and obvious, that have only now been raised as potential issues. I'm not going to get into that issue. However, Mr. Westman and 3A are open to resolving these issues. And we think the way to do that is through a Section 6 finding or special permit in order to place reasonable conditions on these uses. So essentially we could perhaps avoid argument regarding whether the vehicle storage is a continuation of a use, whether the woodlot operation had existed, previously and had never been abandoned. I mean, those are the only real things where we're asking for relief. But we're prepared to work with the board to address that, and I think there's a regulatory vehicle to accomplish that. And to that end, we met with Chair Carchi and Mr. Vogel on July 14th to discuss a path forward. We discussed again no storage of landscaping materials. We discussed potentially allowing the woodlot operation to operate, provided it doesn't get bigger. We discussed hours of operation and typical hours of operation for these uses at different times of the year, because obviously Northern Oaks is busier during the summer months than it is during the winter months, similar for the woodlot operation. We discussed additional screening to minimize the visual impacts to the residential neighbors, and you're all familiar with the site. There actually is a fence that runs along Manlock Road parallel to the street, which does screen what's back there from the residential development, which actually is further to the west and behind. But we discussed perhaps screening along the 3A side of the property. I know that David evaluated the use of the fence. The problem with the fence is that there are moving vehicles. It's got to move snow. The lot is oddly shaped. It's long and narrow. It's nearly impossible to consider a fence. But plantings may be a possibility. In fact, Mr. Westman handed me a copy of a rough idea of a landscaping plan. Again, I don't know whether you want to discuss this tonight or some other time, but there are ways of screening these activities again from 3A, and we're happy to entertain any additional ideas if you don't think that the fencing on Manlock Road is adequate. So again, we're here to work with the board to try and resolve this. I can address any of the legal questions that you may have. I know that town council provided a letter. Without speaking to it directly, I think there were certain assumptions made regarding some of these uses that colored town council's letter. I don't necessarily disagree with the legal standards. I think the application of those standards to these particular facts, I'm not sure the town council had a full understanding of the complexity and the fact that these uses are a continuation. And again, the objective of both 3A, I hope with the town, is that we can continue to have this business at that location, and that we're not going to lose yet another commercial business, out of town to another location, and the town can continue to derive tax revenue and employment opportunities for our teenagers who pump gas. So we're here to work with the board. So thank you, and I'm happy to answer any questions. Mr. Westman's here to answer the questions.
Thank you. So I think the first thing we want to address is the notice of violation. The notice of violation spoke to a violation of section 400, use regulations, the table 420, section 4A, and A, D, and E. Those were the specific violations, and it's basically industrial uses and residential zone. So it was the running of the landscaping business and the firewood processing businesses in the residential zone.
Correct, and I'll refer you I did write to the board on that issue. First of all, none of these are industrial uses, so there's no violation of anything relating to industrial uses under your table of uses.
In the table of uses, it is.
So, which use? They're generally under 420, manufacturing, processing, and assembly. So is your planning the cutting of firewood to be an industrial use?
So establishment for the sale of lumber, other building materials, heating, fuel, livestock, fertilizer, stored in bulk.
But it's none of those things. It's not a lumber yard, we're not manufacturing lumber for sale.
Mr. Patrick? Is this something?
No. Uh,
There's clearly commercial uses, but not industrial uses, and that's what was cited.
Storage boats and storage yard for contractors' equipment, storage garage, trucks, trucking yard, or terminal. So that's 4D under industrial use. So storage of contractors, storage yard or plant for contractor equipment, storage garage or trucks, trucking yard, or terminal.
Again, that was one of the reasons why we agreed to remove the landscaping projects.
Right.
That's what constitutes a storage yard. Separate parking of commercial vehicles, I don't think would constitute storage yard. Again, it is up to the zoning board of appeals to interpret your bylaws if they're ambiguous. I don't think that that's ambiguous. Because parking of vehicles is, I believe, regulated separately.
At the time of the violation, the landscaping materials and all of that was there.
They've been removed. So again, we acknowledge, so at no time I think that we say, we shouldn't have boats there, we remove the boats.
Right.
When we understood that landscaping material would not be allowed, we agreed to remove it, and that's been resolved and removed also. Again, we have this temporary situation with respect to the MassDOT project. But we understood that that had been vetted also by all the officials. So that wasn't reflected as an illegal use, but will be resolved.
The MassDOT thing as a state use, basically, we've been advised by our council that the state can do what the state pleases, and they'll let us know when they're done.
I don't disagree with that.
Right.
That was not, again,
Yeah,
I was led to believe that that was done with the understanding of the town of Scituate. Or whether they had any formal role in that, I do
everything
not know.
that I've heard so far is they know. So the violation called out those uses, including storage of boats, storage of trucks. You're saying all of these have been corrected.
No, the storage of trucks is a separate issue,
Storage.
which is a continuation of a pre-existing use, which we continue to maintain. I'm suggesting because of the historic ambiguity about all of these activities, and I've been hopefully transparent. This stuff's been going on for decades. This stuff's been going on since I've lived in Scituate, which is only 30 years, without complaint, without notice of violation. I mean, it's just, and these conditions exist throughout the time. I'm not excusing them, but these conditions exist. So they have to be recognized in some shape or fashion. Again, I think the way to do this is almost a clean slate approach, which is again why we included a request for a section 6 finding and a special permit, which would allow you to, I guess we would, I'm not conceding that these are unlawful activities, but would address them with parameters. Put a box around them, hours of operations, conditions, so that at least going forward, we can avoid this kind of unpleasantness.
Board, Greg,
I don't,
that's a fellow.
yeah, I missed your initial presentation, Adam.
Yes.
Anything that was new that you did not previously submit?
So I gave a detailed presentation at the last public hearing regarding
Which I was at,
uses,
yes.
uses over time. I can
Yes.
try and go through that.
No, anything new that wasn't previously submitted or discussed?
No, there was.
So the only thing new would be, again, we found photographs of a woodlot operation,
Yes.
1983.
Which were submitted, yeah.
Right,
That's not, yeah.
We met with Chair Karchia and Mr. Vogel and discussed perhaps a way of resolving those issues. And again, the removal of the landscaping material associated with Northern Oaks. Again, we're demonstrating our desire to work with the board and with the town to address these concerns.
I think I want to involve on the notice of violation.
We'll go through, we'll go through the board first. Keith, do you have any question?
No, there were quite a few materials circulated to the members of the board. I don't know who would be helpful for others, but sort of quick read, everything from the bylaws from 1936, which were much more concise than the current bylaws. Yeah, I don't know that it's worthwhile, but is there anything notable that you would highlight as
The gist of the materials that were shared were the gas station existed, predates zoning in the town of Scituate. So when Scituate adopted zoning, this area was grandfathered for use as a gas station and service station. And that has continued to this day. The question we have is, are these other uses pre-existing non-conforming uses? Are they, what is the situation? We have the pre-existing non-conforming use is the parking and storage of vehicles not associated with gas service station is one of them, and then the wood lot is the other. So what these, is established historically is that the gas service station is the grandfathered use for this property. I think beyond that, there was, nothing in the historical data that would indicate anything else.
I just clarified that there's another pre-existing non-conforming use that we're not going to discuss tonight, but to reiterate, there's a tow yard there, separate distinct from the auto service station that existed for decades, through approximately 2006. There have been other activities out there. It's been very difficult to understand over the course of time to try and recreate the history. I provided the historical bylaws to the board just to lock in what the zoning was in 1936 to demonstrate that the uses that existed in 1936 were lawfully pre-existing and non-conforming.
And at that time, it was a storage for the use of a tow business, ultimately, right? Of vehicles.
The tow business came into being after 1936. We don't know when it commenced, but it existed for literally decades.
Was that an extension of the business, or was that a whole separate entity?
Well, it's a separate use.
It was a separate use, but it wasn't continuous, it was part of the station, it was 3A service, 3A tow.
Yep.
Separate owners.
Separate business, same owner.
Same owner.
3A service, 3A tow.
We own the tow yet.
It's Barcelona.
They own the.
He didn't know the towing company.
Yes, he did, he sold the towing company eventually, but he did own the towing company originally.
Originally, we owned the tow.
Three records we had going for the police department for 20 years.
There's pictures of us towing, 3A towing.
I'm not sure the ownership is.
78.
Right, yeah.
It's a separate,
It was the
it's a
same.
separate
It
use.
turned into a
The
separate.
complementary business to the service station.
And
It
it's
was-
separate,
it
I
was
suggest it's
part of-
separate zoning.
It was part of the service station.
Correct.
And then evolved into a split off. But it was originally.
Complemented the existing non-conforming business that was there.
So I have a question about the woodlot and how it's being used now and how it was used historically. Obviously, we reviewed the photographs that
Yes.
you gave, how there was a woodlot there dating back to the 80s. The way that I read the section under industrial uses 4A, which is one of the sections that the violation paperwork was on, is that says establishment of the sale of lumber or, so I would read that as strictly at the sale of lumber, that would be characterized as an industrial use. So is the wood just being stored there, or is it being sold on the premises?
It's not lumber, it's
Firewood's
firewood.
fire.
Right.
And
So there's a
it's-
distinction.
It's the firewood is processed, so they bring in tree length logs, they cut it, into.
Okay, and
they process it.
and nothing is being, when we put it on the record, nothing is being processed there.
Yes, it's
Yeah.
being processed.
No, it is being
Mr.
cut,
Chairman.
it is being cut.
If I might, so I was corrected at the last public meeting, and at the time that we submitted the appeal, I understood that there was no cutting of firewood. In fact, they do cut firewood, they cut firewood. I'm not sure I would describe it as processing or a manufacturing process. It's not as if you're processing lumber, which I think is different than cutting firewood.
Since the thirties,
It's,
since the thirties,
the machine is sold as a firewood processing machine. So, yeah, they're processing firewood, they take tree length logs, they make it into firewood. And then deliver it from there, or sell it from there.
So there is the cutting of wood and the sale of that firewood.
In the documentation we received, there's a approval of that. I know it's been going on for eternity.
I have not found any approvals relating to the tow yard, although there was authorization at one point for the erection of a fence that surrounded the tow yard. I've not found any authorization with respect to specifically on those wood lots, but it's been going on, I don't know.
Doesn't make it right though, right?
I have said, Mr. Fleming, that I have a hard time dating these things when they started. I don't know what the bylaw was at the
So
time.
was it illegal to tow for the police for 2 years? For the town of Scituate?
So where my head's going right now is you got a complimentary business there that's turned into storage of vehicles, albeit for a landscaping business, which doesn't complement the
There have always been vehicles parked there.
understood, but so if you're using the general term vehicles, where does it stop? Do you get 53-foot trailers in there next week and all of a sudden we've got 10 53-foot trailers with trucks attached to it? Cause it's, like how we,
So to your point, Mr. Fleming, I mean, it would probably be productive to have a conversation as to what the expectations of the intensity of that use would be. Again, if the board deems it appropriate to allow that. Our position is that it is a continuation of this historic use. Again, it's difficult for me because I'm by the book. When did the use start? What was the zoning bylaw in effect at the time? Because I'm suspecting that these were all permissible uses under the zoning when they started, because if they were not, I would have expected the building commissioner in 1960, 1970, 1980, 1990 to call out these violations. So my assumption is that these were permissible uses. My difficulty is it's very difficult, given the limited documents that we've got, to pinpoint, when did they start that woodlot operation? And then to do that analysis for you. I can continue my efforts to do that if that's necessary to resolve this. But
if I'm understanding you correctly, some level of what we're working through right now is official approval of longstanding use of this property.
it doesn't need to be official approval. So for example, I mean, and I'm prepared to do this. I can look at the 1983 zoning bylaw and see what it says about cutting wood, and give you a conclusion. But I don't know if that's exactly when it started and whether that's the relevant bylaw. So it becomes almost an exercise in futility, because if it started in 1976 as opposed to 1983, the bylaw may be different. I'm prepared to do my best to do that analysis. My problem is that there's another way of doing this. Again, my opinion is, given the fact that these uses have existed for decades, that they have not resulted in substantial detriment to the neighborhood, because otherwise they would have been shut down, which, as you know, is the standard for the grant of a special permit, that in this case, the change of use, you use the substantial detriment test in your change of use regulation. That the change of use doesn't cause a substantial detriment than the existing use.
So I think one of the things that we're looking at is that a lack of enforcement doesn't constitute approval. You
Agreed, but
can
there's-
speed as much as you want, but when you get caught, you pay the price.
But there are statute of limitations as to alleged violations and when you can pursue enforcement. And we haven't even talked about that. Whether enacted.
But it's active today, right? So if we were to, so if it stopped 30 years, if I'm understanding what you're saying, because it's active today.
Well, no, if you have a structure and it's constructed, depends on whether you have a building permit or you don't have a building permit.
Right,
It's constructed in violation of
Understood.
zoning after 10 years. It doesn't make that structure lawful, but you can't pursue enforcement against that violation. So that's the analogy.
On the structure, use gets that same, I don't think use got that same 10-year. Use doesn't get grandfathered, use doesn't get the 10-year protection either.
And again, I'm happy to do the research to answer questions posed. I was not anticipating that we were going to have an in-depth conversation regarding the violations this evening. It's clearly appropriate to have that. I was focused on the fix rather than.
We gotta deal with the appeal of the violation first.
So somebody, ultimately a complaint came in.
Yeah.
That we now have to respond to, right? And utilizing this and whatever information you have. The information you have is nothing, it's pictures of a previous use, which is helps the discussion, but I don't think, and I'm not an attorney, admittedly, I don't think we have some closure on a complaint. And we can't say because it was previously used and it hasn't been complained about only until today, we approved it. I
So
think we have to
again,
reference
this is
some tangible.
This is for
information.
Mr. Vogel, but typically when served with a notice of violation, the town's interest is to get compliance. So with respect to the boats, there was a violation, we admitted to the violation and we removed the boats curing that. So if you wanted to uphold Mr. Vogel's violation with respect to boats, you can, it's somewhat pure in that we've acknowledged that. With respect to industrial uses, I do not believe that there's a violation of any industrial use, so we're left with the trucks, the vehicles, and the woodlot.
And your goal today is to put terms on what vehicles may be able to get stored there in the future?
So
Is that what you were hoping to
our
do
goal,
today?
our position, our legal position is the storage of vehicles is a continuation of pre-existing use that should be allowed to continue. It doesn't constitute a violation. With that said, because of the historical ambiguity regarding when these things occurred and what authorizations occurred, who the building inspector was, what was the applicable bylaw at the time, I thought that the solution to the problem is, again, a section 6 finding / special permit that addressed the vehicle storage as well as the woodlot. Again, when we filed the appeal, I wasn't even aware of the woodlot operation actually existing back into the 80s. I thought that the woodlot operation started in 2016 when the towing operation ceased. So that was a piece of new information. So in my request for relief, I said, yeah, that's a change of use that needs authorization. So if you want to find a violation for that, we conceded that, but now I know that the woodlot existed in 1983. So it's the same issue. It's a continuation of a prior existing use that I can't date the commencement. I can't date which bylaw applies. So if those are the two issues, I mean, our position is that there is no violation and that you should reverse Mr. Vogel's determination on those two issues. As I said, if we have a path forward to resolve this by section 6 finding or permit, I mean, perhaps as an as part of the settlement of those issues, do we withdraw our appeal of the violations? That takes that issue off the table, so we have a clean slate. I'm thinking outside the box here that may avoid the board having to make a hard decision and avoids us being, contrary to Mr. Vogel, which we don't want to be, and maybe we address it that way. Or if you wish to rule on the violations, our position is that there are no violations.
Let me go to Bob. Bob, where do we stand with the violations? Have you been there since we removed all the landscaping material and things like that?
It's difficult to know whether the landscaping material is part of what's happening on the state's end of things, or, there's still piles of dirt on the site.
Yeah.
I'd be willing to believe that most of that's the state's, situation.
I think everything to the
From the
right hand
north
side of
down
that
and
line is.
2/3 of the back are now taken up by it.
It looks like all of the landscaping material was to the left and closer to the fence,
Is
just
great.
in the area.
Yes.
So. Greg, I'm gonna lean on you for this one.
Well, for Bob, if that is for the state, then are there any active violations?
Well, I haven't walked the site, very honestly.
But comparing, in essence, with your letter, the terms of your letter.
There's a couple of other issues here that I'm still unclear about or curious about.
Yeah.
I guess starting with the wood, very interesting to see those photographs and that they date from 1983. However, I think that there's a gap in the sort of proof of that particular contention by Attorney Brodsky that it's a pre-existing continuing use that should be allowed to continue today. It was never permitted, it was never a lawful use within a residential zone. You can look at all of the zoning bylaws you want, and you won't find that particular activity allowed in a residential zone anywhere at any time.
It's not allowance by omission, it's allowed.
Right.
Yeah.
So there's that, and then there's the wording in section 810.1 that basically says, no non-conforming use once abandoned or not used for a period of 4 years or more should be allowed to be restored as a non-conforming use. So you would have to prove first that it pre-existed zoning, which is 1936. You would have to secondly prove that it was in continuous operation since 1936, at least to the point where it had never been interrupted for 4 years or more, to make it, to make an airtight case for allowing it to continue. And I think you could say the same thing for vehicle parking, although it's less clear to me. Certainly vehicle parking is part of what happens at a gas station and service station. So I think in that case, it's a degree, maybe a type. I mean, you wouldn't want to see, as Greg said, a bunch of 18-wheelers parked out there all the time, but there's certainly a connection.
I think we have, the near maps, we have aerial photography that we can date back to 2014. And it shows that lot empty between 2014 up to almost 2022. So there was
There was
no,
a boat and 2 trailers there when I took
And
over in
one-
14. In 14,
right,
existed through
there was,
almost 17, 18, before I could get them to get that out of there. There have been other vehicles stored. If you look in the aerial shots, you'll see cars from where the woodshed is, all the way over to Manlock Road, that whole back is
in
full,
the
all the time.
back, right, not in that tow pen where the firewood
In
is.
the tow pen was
So,
also
excuse me,
all
ma'am,
the buildings
ma'am.
for the trees. They were in there.
I'm gonna ask, I'm not gonna talk over you, please don't talk over me. I will allow everybody to talk that wants to talk. Don't talk over me, please. I mean, we're looking at photography that, you know, shows empty lot, and
It
it
shows
shows
it's
cars, and I'm just, Dave, like I just said. That shows cars that, you know, part of the mechanical operation, they're parked in that kind of, you know, right by the bays. Nothing in the field for years. So as far as a continuation of a woodlot operation, you might have pictures from 1983, but I'll tell you that from 1997 to 2000, however long I was, working over in that area, the lot was empty. There was no firewood processing there.
There was nothing. They're not claiming that there was continued firewood.
Well, that's the issue we have, is the use has to be continuous.
So, Chair Carter, which is why in our appeal and our application for relief, requested change of use for the woodlot operation. I was pointing out the 1983 photographs as creating confusion regarding, the point I wanted to make is that this is not a new use for the property. We have requested relief specifically with respect to the woodlot operation. I just want to make that clear.
So we're not claiming that this is a continuation, an extension of a previous. It's similar to what happened there years ago. I think is the contention we're making.
Correct, and I don't have access to your map information, so if you'd like to share it with me, I'm happy to review it.
I've seen them, but they're not detailed enough to see.
I know that.
Well, then you would have seen the boat. And the
I've seen it, I've seen.
Well, how do you say it was empty then?
Casual use of one boat sitting in a corner isn't the same as operational use of,
It's not abandoned.
We also stored the twenty buildings.
It's not.
So all I'm asking is that if you're relying upon near maps for a particular period of time, would you be so kind as to share them with us so as we can talk about them? I have some near maps that were submitted by, I think the Butter got these from the
Yes,
But that's, I mean, they're for selected periods of time. I don't, again, it's September 14, 2014. Then we're in October 6, 2016. Both of those photographs show automobiles, so I don't know what the point is. And then we're jumping to 2019, 2020. I mean, you can, depending on when you take a photograph, there are different conditions. So it'd be very helpful for me to understand what the board is relying upon. So at least we get to speak to that issue.
and I know you can pay for the service, I don't know, maybe get you the service.
I don't have
Yeah,
I don't have a
yeah,
subscription,
yeah.
but if there are documents in the record that you're looking at, I just request that you please share them with us, so that we can at least see what we're talking about.
Anything else from the board?
Wait, so the range of potential outcomes here, right? Just so like we grant the special permit finding and presumably put some parameters around the woodlot operation and or any other activities at the site, right?
I would honestly do two, it would be woodlot operation and parking.
Yes, okay, so that's like one potential outcome, right? And then we'd have to like sort out exactly what the conditions and parameters are.
Correct.
The other outcome potentially is to deny the request for special permit finding, and then what happens next?
We would deal with the notice violation, it'd still be a notice violation at that point, because there would be no special permit that would make the acts permissible. So it would
Okay,
be,
then what happens next?
so there'd be a notice violation, and obviously then Adam would have recourse, either appeal or not. If he did, obviously we go up. If he did not, then if there was a continuing violation after that, I believe the commissioner would have the ability to impose sanctions on the lot holder.
Ultimately, you can shut them down, and empty lot at the gas station.
Yeah. Fair enough.
Good. Members of the public. Does anybody care to speak on this?
We always stored stuff in that
Ma'am?
field.
I'm gonna need you to give me your name, your address.
Marion Scarsaloni, 766 East Douglas. And we have always used that field for storage, always.
Police towing, that's why the fence was up.
It wasn't just when Tom McKay was bringing his vehicles in, because I was running Tom McKay's business at the time and got him started. And we had vehicles out there long before Tom McKay. We turned the towing business over to Tom once I got him started and up and running.
Yes.
But we've always had cars stored or something out in that pen area. We put up the pen because idiots in town were breaking into the cars we were hauling for the police department and stuff, getting into stuff they didn't need to be in. So we put up the fence and it also sheltered it some from the road, from being seen. We've always had cars that stretched from just before 3A, right around the business, and Teddy Bo's big dump trucks and stuff were always stored in the back there. We've always had business vehicles, we've allowed people, yes, we have the space, you want the business, let us help you out. And that's the kind of town this has been, until now. Now we have people that have too much time on their hands and have to get into people's business when
All right.
a simple thing would have been saying, Dave, we need to get you a compliance or whatever with this, and done, over with, instead of all this hoopla. And
You know, I stopped and told him, which costs money, 76 Chief Justice was back. Oh, no, of the property for 70 years. I'm gonna say one thing. We cut wood for the poor people and said, this town, we knew everybody. Not now. They came down a block and filtered through. The big wigs, they think they are.
back in 36,
Yeah.
they were cutting firewood.
We cut firewood for the poor people on that property in the 30s, 40s, and 50s, because we burnt wood in the gas station and potbelly stove to keep it warm.
And I'm not disputing that, and
I mean, look at the thing, in the 60s, I brought down trees from New Hampshire and cut them there.
and now we're at 2025.
And they're still cutting firewood for people in town to stay warm in the winter.
I understand that.
There are some poor people this time, you know.
Yes, there are.
Yeah, well, the board and the rest of the town should find their way to help them.
Ms. Lambert?
Tricia Lambert, 14 Alexander Place. I wrote the letter of violation, and I have known Mr. Westman and Mr. Ritter for over 50 years. It is not my intent to drive them out of business. That is not my intent at all. What is the intent is that the zoning bylaws, rules and regulations are legal documents written by the town, passed at town meeting, and then approved by the Attorney General. And only what is in those rules and regulations are allowed. How this came to my attention was that when Mr. Leach wanted to redevelop his property in Greenbush, it was asking him what was going to happen to his business. And the response was he was going to sell it. So suddenly, to have a landscaping business which is not allowed in a residential area, and I know that there are lots of places in town where that happens. And, you know, I happen to live right beside there.
How long you lived there, ma'am? In town, in Scituate?
Mr. Scarsaloni,
You have to speak to Mr. Township.
address to me, address
I'm
me.
sorry, I wanna ask her how long she's been in that area that she's complaining. How long she lived in that?
Do you care to answer?
I've lived in Scituate. I grew up in Ottawa for 6 years.
Yeah, I was born in Scituate at the house.
I know where you live, but I was grew up on Ottawa, and I've been there for 60 years. And I've been off of Denmark Road now for almost 17 years.
Well, I've been there 87 years.
That's it, Mr. Chair, I am not arguing now,
And
what I am arguing is that what is in your zoning bylaws, what you need to.
Correct. Let's keep this professional and civil. Nobody, we're not trying, she's correct. We're not trying to put anybody out of business, but we need to do this right. And we need to do this right, which means that to have a wood cutting business in a residential zone, you have to come to us and, we have to figure out how we can do it. To park vehicles in excess of, accessory to a garage. You need permission to do it, we need to do this right. That's all we're asking.
I don't know the circumstances too, but on a tow yard, is there hours that that same vehicle can be left on that property?
No, it's no.
There's no limitation to,
No, a tow yard is, police call.
Well,
there's an
right,
accident-
No, he's asking how
there's an
long a
accident,
vehicle can
right,
stay
yeah.
in the yard.
storage of vehicle, but I don't know if there was a
There's
condition
no
on how long
limitation.
they can be
No.
stored for.
In the back,
Yeah, I'm Stephen Leach, I own Northern Oak Landscape,
yes,
and
sir.
I live at 58 Clap Road. And I am developing a property at 19 Ford Place that we ran the business out of back, after started Northern Oak in 1983, at this town hall. We incorporated in 2000, and we've been running it almost 43 years in Scituate. And we've employed hundreds of really great kids and really enjoy what we do. And I'd be willing to have Bob meet me tomorrow morning at 7 AM and walk around the property if Dave is okay with that. Or a tour of the property.
What's he gonna see on the tour?
Was that?
What's he gonna see on the tour?
Well, he questioned piles that I might have.
He can see that he's
Tomorrow
not,
morning, we could walk around. And see
I think we
what-
all agree that the
Yeah.
landscape material has since been, and any stored materials on
I-
site is assumed
Yeah,
to be.
I'll take, yeah.
he's not running a business.
I'll take,
Correct.
Mr. Sorrells and Dave's word that, you're not running the business, parking the vehicles.
Is it temporary?
Is what they're claiming, is that you're parking the vehicles there only. As we drive down this road here, when we get to whether this is gonna be allowed, whatever, we're gonna get into, we could get into conditions. So I'm not gonna get into the details of what's there right now, I wanna deal with the violation, how we're gonna move forward with this. In the back.
Jeff DeLisi, 318 Country Way. It would seem to me that the applicant probably has a business that makes various uses throughout the year that are similar to the grandfather use and spun off therefrom. I think that the table of uses deals with principal uses. And if there's a periodic parking of vehicles or periodic allowance of the landscaper to use the property, that's kind of incidental to nonconformity. And the way I think that the board should handle it is to table the discussion about the violations and allow an application to proceed on whatever the uses are, and allow the applicant to demonstrate whether it's substantially more detrimental to the neighborhood or not. Like, that would cure the violation if you were to find that. And it would allow a business that has existed in this town for like 100 years almost to have some deference by this board to grow and to grow with the times and survive. Because ultimately, what you're looking at is a fairly significant parcel of land that if this board, if the bylaws were read stringently to the point that it couldn't remain a viable business use, in all likelihood, you're looking at another 40B project. So to me, it makes a whole lot of sense practically to recognize that this is a business, a longstanding business that has done good for the town, and try to work with the applicant to see whether or not whatever uses may or may not have occurred, or violations that may or may not have occurred, could be legitimized through the proper process of a special permit. So I would recommend that the board continue this, allow the applicant to file an application and run both simultaneously, one's gonna move the other eventually. That's how, and to me, it makes sense to do it, look at it that way.
I appreciate that, thank you.
Well,
Anybody else in the audience? I don't see any hands raised online.
Chair Carter, I'm very appreciative of Attorney DeLisi's wisdom here. He doesn't know that you do have a pending application for relief in front of you. That's part of what's being said. And to follow up on that, as I offer it, I mean, if you do grant the relief, the violations are removed, we would withdraw the appeal, and there's nothing for the board to rule on that.
So that's my table. So right now, our options are one to either close the public or discuss. I think that what the board really needs to figure out first is if we're inclined to grant a special permit. We're inclined to grant a special permit. Adam and Jeff are correct. The notice of violation is needed.
Then I'll entertain a motion to close the public hearing.
Okay, sure. Like Archer, if you wish to discuss conditions.
Not yet, I think close the
Well, but
public hearing.
if you close the public hearing, will you allow the applicant to participate in conversations
Yes.
regarding those conditions?
Yes.
So perhaps is it better to close public comment as opposed to
Yes.
close the public hearing?
Close public comment, make a motion to close public comment. Second. All in favor? Good. Board, where are we? Make that clear, because, say that again, so we're going to,
I think we first need to determine if we are inclined to grant the application for a special permit to essentially make, not dealing with grandfathered use or anything like that, to allow the uses
to allow, right.
We're skipping all those, this is historical, it doesn't matter,
Extension of pre-existing.
doesn't matter. Are we just allowing it? By special permit?
Right, moving forward, we want to be able to park vehicles. Let's go with park vehicles first, I think that's the easier of the two.
And what do we mean by, do we want to put in, obviously, do we want to put conditions on what constitutes a vehicle, or do we want commercial vehicles, or we only want?
The language of contractors' vehicles, that's specific to that violation, but it'd be obviously worded into the special permit if it's just contractor vehicles.
This started with running a landscaping business, so is it, we're gonna say we can only park these vehicles, or are we gonna say we're allowed to park 10 vehicles? I think it sounds like the consensus is parking of vehicles will be okay, would be permissible, even accessory to a service station. With conditions.
I mean, it might be easier to say what we don't want rather than what we do want, because
Right.
don't want tractor trailers.
So that would be my first.
Don't want heavy equipment, tractor trailers,
Otherwise, we're.
buses, we don't want to fleet of buses.
Anything hazardous.
Right.
The town is actually
And,
approaching
and,
twice.
and as just as I was saying that, I know, yes.
Sure, Archer, again, I'm very helpful to have indications from the board as to which way they're going. We certainly would be open to continue the public hearing. We'd be happy to give us some guidelines to propose conditions that could be reviewed by the board, which we knew would be acceptable to us. Like I mentioned, we've got a screening plans, but I need to submit it, and we haven't submitted it, which I can't. But we could come forward with a proposal to give us some sense of what you think is within the range, and then be more specific about that.
So before we get there, do you want just same discussion about the woodlot?
I think we should go through all of them so that Adam has And then see if Adam still wants a continuance, and then so we're not back and forth 20.
Yes, yes.
So that's cars.
So that's,
Vehicles.
so that's parking, that's parking.
Just keep using the word vehicles, but it sounds like it's more for the use of construction or landscaping trucks, right?
I think commercial, I think it should be commercial vehicles within limits.
There you go.
You don't want, you know, we have to define a tractor trailer, you can have a trailer or a small piece of landscape.
It might be that
Versus
under
a
certain
60, 70 foot,
yeah.
you know, tandem trailer, I mean, right, I mean, those are the sorts of things.
Across the street from my house, I have a site pro, and they're going way back, their conditions, one of them is, you know, hours of operation, they're not allowed to roll out before 7 o'clock. Something along those lines, you know, hours that, you know, we don't want trucks in and out at 3 o'clock in the morning, and I know you plow, so snow emergencies would, you know, be, you know, an exception to that.
My plow truck would be there if it's
Right,
snowing
yeah, but
anyway.
I know Northern Oak
Yeah,
themselves
Yeah.
plow, you know.
Yeah.
So, you know, if
You're
we
saying
said, if we said an
activity would be
hours of
there.
operation,
Yeah.
that would be exempt from that. But, you know, we don't want, you know, the fleet rolling out at 5 o'clock in the morning and rolling back in at 10 o'clock at night kind of thing. So it would be hours of operation, it would be size and type of vehicle, it would be, you know, a limitation to hazardous materials. One of the other things about this piece of property is that it is in the water resource protection district. And it's in the zone C, so it's very lowly regulated, but again, no.
I've reviewed the uses,
Yeah.
none of the proposed uses are.
Well,
prohibited
exactly,
uses.
but I don't want leaking trucks, you know, things like that. I think that's just something we wanna stay on top of.
That's why I turned down the school buses.
Right.
You know,
You know, so there, it would be things like that in those type of, conditions. Anybody else with any thoughts on?
I would say
Limiting the materials that are stored in the trucks overnight. You know, obviously, we already talked about the landscape materials themselves, but being loose on the property, but whatever's being contained inside those trucks
Right.
overnight, I think some should be subject to some sort of limitation.
The only materials I can imagine would be in trucks would be
Right.
landscaping
Mulch,
materials like
grass,
grass,
like, yeah.
gravel.
Tools.
same stuff that was on the ground. that
I
had-
mean, they don't transport hazardous
Yeah, well, yeah,
materials or solid waste.
No, but in case it was a different business in the future, that would be utilized.
Yeah.
Not a landscape service.
Right, so I mean, a general prohibition against the storage of
Yes.
oil, OHM or solid
Yes.
waste, I get it. We wouldn't want that on the property anyway.
Right.
Is there a way to, within the property, limit, so it's condensed and it doesn't become, if we say 12 vehicles scattered throughout?
So one of the items that came up is that there's actually two pieces of property here. There's the front lot that the gas station proper sits on, and then there's another lot behind it, owned by Mr. Scansloni still. And in the near maps, and I'll show you, but you can see that it's creeping back to that second lot. We'd like to make a restriction, keep it restricted to the one lot.
The pen is located on the second lot, so.
Not the way the Pearl, no, it's all, no, that lot does a weird
all
thing,
yeah.
that corner is part of the first lot.
It was reef
And there's
shape when I
there's
bought it.
a residential lot behind.
I have the historic title plans in my
Yeah,
brain,
yeah.
for lots of them.
So I would condition it to any of these activities remaining on the one lot and not extending into that second lot.
The second lot isn't even before us, correct?
Correct, well, correct, but if you look at what's going on, it has crept into that space.
Right.
And we would want a line drawn, a fence put up or something along those lines. You know, to say everything stops here. Yes, I think what Justin's getting at is, are we gonna limit, to a certain amount of space that you can park trucks, so there's not, I think that might get into the number of vehicles and not
Which you'll
the
ultimately,
amount, right?
yeah, correct, you're only gonna be limited, it could be 6 big trucks,
Right,
10, vehicles.
So I think that might just.
So if I might suggest, we could take, a plan and show you where the trucks would be located, where the cleaning is located, so that it's contained, everyone has a plan that they can rely upon.
I don't think the number, I don't think we can put a limit on
Yeah,
the number,
we can
because.
Well, I'll tell you, Site Pros, you know, the one for 108 Stockbridge does have a limit of vehicles on the site.
Well, let's.
You know, do they get counted? No, but you can, if there is a precedent.
Actually, not micromanaging them, can we just have them go park behind the fence?
Right.
Yeah, let's see what happens.
Yeah.
Well,
So we got, right,
We got parking done. Anybody else on parking?
what about, what role does precedent play here?
None.
I know that we're none, so
no,
from a
None.
legal
Yeah,
standpoint.
none, but yes,
The
there
heck,
there
then
is.
from a legal standpoint, the next time,
property,
shows up.
property is unique, and this is a unique property of historical use that is unique to the town. So that's.
but the next time a case like this comes in, somebody's gonna say, well,
You let them
instead
do
of
it on
one, or this one, you did this,
Well,
right?
I think we can
Yeah.
deal with that at the time, but again, the property is unique, so I don't think we are really setting.
Well, I mean, that's fair enough, like, from my perspective, right, this is like allowing a different use in a residential zone. I think we should sort of start with I would start with the assumption, right, that residential zone should be for residential use only, and now we're sort of stepping back on that, which is fine, but, we do that in other cases, but.
But you could cite the pre-existing
Exactly,
past uses where it's something new starting up,
yes,
it's very different than
It's-
something
well,
that's
exactly,
been
exactly.
on and off
exactly,
since
So
the
that-
nineteen
That
thirties.
kind of situation gets dealt with.
fair,
A new business comes into town, we wanna operate here, you're gonna go before zoning. Yeah. All right, we'll go with parking, so woodlot operation. I can tell you that the discussion that Bob and I have had, we've spoken with them, the initial gut reaction is sale, but it doesn't, it's not what they're doing, it's kind of not what you're looking for. It's not like you just wanna sell firewood, it's the fact that we're processing firewood on the property.
And to be clear, they only process from 9 in the morning till noon.
But if I say, yes, we can allow firewood processing here, what happens to the next guy that buys the business and says, they're gonna process firewood here 24 hours a day? You know what I mean? So he might only process firewood for 3 hours a day, but I don't know about the next guy, so I
But
think.
again, you could place
So we could,
conditions
exactly, so
on
we
the
could,
use
it would be,
consistent
it would be.
So it would be a confined use with the hours that are mutually acceptable.
I have,
Is that set, 5 days a week, the 9 to 12?
Monday through Friday, 9 to 12.
and didn't he, you're the firewood guy, actually.
Yeah.
Yeah.
You can bring up 24 by Wood Lane, Scituate.
Thank you.
I went to school, I think, with your brother,
My
your uncle.
more of a hobby than anything else it looks like, if you're looking
It
for 3
is.
hours a week.
I was in the beef business for 40 years, certified Angus beef, the first licensed distributor in the whole world.
Oh, wow.
Big warehouse in Westwood, ran tractor trailers down the East Coast for 40 years.
So, same thing, we can do this with conditions. What kind of conditions are we looking for to put on this?
You could put the hours of operation for
So
both,
hours of
something like
operation, but I would
7
locate-
until 5.
And location.
Location on the lot would be another one. I think size of the machine, because I know the processing machine that I've seen on the picture of it is a smaller one. Taylor Lumber has a monster fire.
Yeah, these are small machines. I have three splitters.
Yeah.
One's a processor, 4-way split, it's all the way in the back. Then I've got a pretty good sized splitter that will crack the big 3-foot rounds, and that's pretty much it.
So
It's
is there-
all divided tractor.
So do we condition the size, type, that kind of thing?
Essentially what's being currently used.
Yeah, to what's being currently used.
At this time,
How about maximum amount of material stored on the property?
I think that gets to probably gets to where it's allowed.
But would that go, the space that's allocated?
Space that's available.
once you decide that you're fine with the wood lot, right, like just like 9 to noon or 9 to whatever, and then.
I think this location on the lot will dictate what they can do.
Anybody else with any thoughts on woodlots?
I mean, it's not lumber.
And right, we're not processing, we're not making boards, it's a sawmill.
Adam, anything else?
No, happy to take all of your input, come back with you with a, I'm not sure, I got a sketch, I'll have a sketch, I'm not even sure I'm gonna call it a site plan, but a sketch showing this with proposed conditions that address all of your concerns.
Adam, do you want 1 month or 2?
We should be able to do this.
Eric, how are we looking for next month?
We have 5 on the agenda.
We can take 2 months?
Joking, no.
You don't have to, yeah, like we were.
Is there any sensitivity to
actually,
the
yeah.
violation? Very sensitivity to like that violation.
No, because I think at this point, the violation goes.
If we got in currently the violation.
If you need 2 months, that's
No,
fine, we wanna resolve it.
No, we can do it, I think we can make the next meeting short.
Try to get it back.
Eric, what's the date for the next meeting?
Thank you.
All right, Adam, do you want to continue to September 18th?
Please, thank you.
Make a motion to continue to September 18th.
Second.
All in favor?
Aye.
We'll continue this to the meeting.
Thank you.
Thank you very much.
Oh, is that what was going on? It was us, yeah. It even cost. Yeah, Greg in there. No, there was one.
Oh, yeah, 10 Meadow Road, looks like a. That's like, yeah, 43, 10 Meadow. Just FYI, try.
I know, and the 2 minutes that I was being late here was the worst 2 minutes I spent in my life.
Oh, no.
I had to wait for that. As a result, I do appreciate it.
So far.
All right,
I know this place.
we're all settled in for our next hearing, for the second application, Jeffrey and Cynthia Schechter, 143 Jericho Road and 10 Meadow Road, Scituate, Mass. Applicant seeks the following relief to allow the construction of an addition to the dwelling at 143 Jericho Road and to raise the building at 10 Meadow Road. Session parcel. Special permit pursuant to zoning bylaw section 470.6.f, substantial improvement to an existing structure in the floodplain and watershed protection district. And number 2, a finding pursuant to zoning bylaw section 810.2C, proposed modification of a pre-existing non-conforming building on a pre-existing non-conforming lot, not substantially more detrimental to the neighborhood. Any other relief the board may grant. Mr. DeLisi.
Oh, thank you so much. So for those of you who don't know me, Jeff DeLisi, or Robert DeLisi and Harry. A few months back, I don't think the composition of the board was exactly the same, but a few months back, I was in front of this board, Frank Snow's project out in the same vicinity. And similar to that project, there was a home that was essentially surrounded or close to being surrounded by salt marsh, which was dilapidated, and something needed to be done. In this particular case, the Schechters, Jeff is sitting next to me, his wife Cindy's in the audience, recently were conveyed a parcel of land, which is 10 Meadow Road, which is behind 143 Jericho Road, which is the property that they own. And that property contains a similar situation as Mr. Snow's insofar as there is essentially a structure that's not being used that is, in this case, much larger than Frank's structure. In a similar area. And in this case, I'm very happy to bring this particular application before this board because it allows us in one fell swoop to do an addition onto this this home on 143 Jericho. The addition is relatively small and fully within the conforming setback. But this project introduces something a little different, and this project introduces the raising completely and removal of the home on Penn Meadow Road and the return of that property to the natural state. So one of the reasons why we're here is all of this property is located in the floodplain. And in order to do any work in the floodplain, you need a special permit. So in order to do the addition, in order to do the raising of the home, we would need a special permit. So in the floodplain. But because we're here, I feel that it makes a whole lot of sense to request a Section 6 finding on the addition, so that everyone's clear as to what we're up to. In this case, the combination of the two properties are over 30,000 square foot, 10,000 square foot zone. The house, in which is the R3 zone, the home on 143 Jericho is non-conforming in the front yard setback, and there's a non-conformity in the side yard on the accessory building. The proposal, if you've seen the plans, is there in orange, which is essentially to fill in the space between the home and the accessory building, so as to allow continuous dwelling into that space, essentially. All of the work is in the conforming setback. And so really, you know, this is an opportunity here, a very unique opportunity to allow an alteration to a pre-existing non-conforming structure, which does not even increase the gross square footage of the space by more than 20%. But also to allow a special permit for that to happen, plus the raising of the house, most importantly. In addition, the plan, which was provided to you, contains an area in yellow. You have the colored plan, correct? Yep. The area in yellow is a deck, and obviously there's some blue, and that's a little plunge pool on top of the deck. The pool's not sitting into the ground or into the grade. It's elevated. And just to give you guys a sense of the space, it's just easier for me instead of handing out packets. This here is what the property is. We have the home, the accessory building, and the house to be raised. You can see this fairly large home to be raised. This here is kind of a more close-up of the two structures that are on 143 Jericho that would be joined. The deck would be kind of off in this area here. And then this is a photo of the house that's being raised, so you can get a sense of the scale of this and how much good that this project is doing. The net difference in the impervious area is reversed in this case. We're increasing the amount of impervious pervious area. We're decreasing the amount of impervious area by over 1,000 square feet. So that's the project in a nutshell. If you have any legal questions or factual questions, I'm more than happy to answer. I would have hoped that I would have been here before the last meeting because it seems to me to be kind of squarely, kind of a good project for you guys to approve, and I was kind of hoping it was in and out, but couldn't make it, I apologize, but thank you.
Board, any questions?
How much is the house being raised out of curiosity? It's on stilts, it's just,
There's about a 10-foot cement foundation, I think Jeff has the pictures. I mean, the house is in a total state of disrepair. It's a complete eyesore. It's been abandoned for years. I can't stand looking at it.
If there's a house that sticks out like a sore thumb over that corner,
That's
it's
it.
that thing.
And there's a beautiful marsh and a view, which we hope to integrate.
Are you gonna restore the marsh kind of thing?
We're gonna plant vegetation there, you know,
We
so,
know nothing about that, and so we're hoping that there would be recommendations from someone within the town to tell us how to restore the marsh to its natural state.
including Frank. Who knows a little bit about conservation.
They've been working with Frank on this a bit already. Right now, there's no proposal, to alter or alter the land to create a wetland or anything along those lines. We're viewing this as a net massive positive for the wetland in and of itself. But as the Schecters have indicated, it's probably something that's likely to be coming. We have an application already that's filed with the Conservation Commission for this project.
So
sorry.
the orange bit, you're gonna basically join the house with the accessory building, right?
Yep. And notably, all that work is within the conforming setback.
Yeah.
So there's no alteration at all of anything within the non-conforming setback.
But you're just snug on the one side, right? Yeah.
in the number 10 on Meadow Road, that's just raising, not reconstruct, just raise.
Just raise, just literally remove it and, allow the natural habitat to take over. The red line that you see is just the limited activity.
That's,
Yeah.
Anybody else? Bob, you got anything?
No, not really. I think it's like you, I've been by that and wondered what the devil I was looking
Big
at.
thumb that sticks up.
And it's nice to not have to look at.
Members of the public, go ahead, name and.
Can I come to the table?
Sure.
Because I have more than a comment.
Yes. Would you sit next to me? Your microphone.
Next to you. Thank you.
You're welcome.
So that's good to hear some of the things you said, that's good. My name's Joanne Wyckoff, I live at 154 Turner Road. I live right on the Sand Hills Salt Marsh, just like these people. And I'm also the co-founder of with Della Shepherd, who is back there, of the nonprofit advocacy group Scituate Salt Marsh Stewardship Initiative. The salt marsh is the real abutter here, is one of the many abutters of this property, and we're happy to see that this house is going down. But I wanted to also, we know a lot about the Sand Hill Salt Marsh. It's a 7-acre salt marsh, and the neighborhood depends on this for flood control. And two things of note that I would like this audience to hear, that the town has dedicated $50,000 for tidal monitoring for the Sand Hill Salt Marsh. And that's a first step in the restoration of the marsh. And in addition, I don't know if this body knows this, but the Sand Hill Salt Marsh was studied over the last year by the EPA and by the state CZM, along with 44 other New England salt marshes. And it was designated as one of the top 11 for restoration, for high restoration. So that's a good sign that it's going to be looked at and dealt with. And also that that's another reason why building around this marsh should be cognizant of that this is a vulnerable resource, and the Schecters have a wonderful opportunity to engage in a very marsh affirming project. Now we have some questions.
only 8 of them, if you don't mind. Now, the properties have been merged, but there was no supporting documents about that merger in the filing. Can we see those?
So I think the deed that merged the property was included in the filing. Because I was careful to merge it before I filed. So let me just check, see if I got the answer to that.
Okay, do you want me to go on? Please. Any other question?
Yeah.
We found the plot plan very difficult to figure out. We thought that a real survey of the merged land showing more in-depth elevations, terrain structures would be really useful, and we thought the building department would require it because this is going to have a big impact on a wetland. So we felt more information seemed warranted. We also had lots of questions about the plunge pool, which is pretty large. It's gonna be in the ground, up in the air. What kind of setbacks are in for this kind of thing in a wetland area, and what about the effects of storm surges on a plunge pool? The plot plan didn't help us solve those questions. The impact of the other alterations, will this be a 2-story, 546 square foot addition, or a 1-story? This orange thing.
Keep going.
We had lots of questions.
I'm taking inventory.
Will they be detrimental to the neighborhood? Will this be a 2-story, a plunge pool on piles, a deck on piles? It was hard to figure out what was what. So that was, okay. And then the regulations state that there is no building in the 50-foot buffer to a wetland. And yet, all the new construction, I understand all the new construction, I live there, is within the 50-foot buffer. So how does this comply with the zoning bylaws for the floodplain and watershed protection district? That's another. And okay, the demolition is gonna happen, we understand, it's going right down to the ground, correct?
Yeah.
The foundation is gonna be, okay, and the demolition permit.
Within the 50-foot buffer.
Well, half of the house was, yeah. Has a demolition permit been issued for the Penn Meadow?
No.
Not yet. Okay. Regarding the tear down, taking down the house is wonderful. Thank you. That is good. We do not see anything that actually commits the applicant to keep the property at some kind of unique conservation value except by what you said. So a permit, I would think should clearly state as a condition that both lots in the permit should be recorded and indexed at the registry. There should also be a condition in the permits that no building should ever be built at 10 Meadow Road again, nor should there be access to 10 Meadow Road from the marsh side. Have the applicants considered putting the land at 10 Meadow Road into conservation or donating it to the town for conservation? And the last point is, in a special permit, would be to require that the applicant, this is where we could help you, but you don't have to take our help. Coordinate with the Conservation Commission or us or the Beautification Commission to preserve the parcel in a manner that fosters the goals of the floodplain and watershed protection district. Cleared parcel should be allowed to revert to the salt marsh, which you said it would, or be revegetated with native species to improve water quality.
So that's quite a bit. I'm more than happy to try
I'm
it.
happy to share it.
Right.
We can have.
No, please. Just kidding. I appreciate, I understand the passion of the group that has showed up at the last meeting and showing up here tonight. I understand that the
And we know a
focus-
lot.
The focus
We know a
of the
lot,
group
too.
is wetlands and the preservation of wetlands. Couple of comments. Number one, I just simply cannot recommend that my client voluntarily restrict their property such that they might not be able to make use of it in the future in a manner that is consistent with the law.
So you want to build on it again?
So, no, didn't say that. What I'm saying is that there is, it be unusual for this board to impose a condition that says that we can't do things that we're not proposing, which are not contrary to zoning, in a circumstance where there are many other abutters to this wetland, such as yourself, who are not agreeing to those types of restrictions either. So just respectfully to the group, is Schechters are doing something here that is tremendous benefit to your interests. And there is no proposal to put anything on that property. But I can't recommend to them that they agree to a land use restriction, and I would fight it if
Or
this board
conservation
were
restriction.
to try to impose. That's number one. Number two, the deeds are in the filing, so they're there. The property has been merged. It's part of the filing. I'm happy to talk to you afterwards.
But I saw the two
They are.
separate deeds. This is the merged deed. Which one is that?
So both deeds have the same grantee. So
Okay.
once the property goes into the same grantee, Bob, I think that's something that you deal with often with commonly owned property, it becomes effectively merged. So for zoning purposes, once it goes into common ownership, it's merged. The pool is above, is elevated. If there's a storm surge, water would flow underneath the support, just like any other water flows underneath.
But that
decks.
seems more like a hot tub, not a plunge
It's
pool.
like 8 by 10.
And how deep?
4 feet.
4 to 6 feet. This is not a big
It's a
pool.
big lot.
Because I've been studying plunge pools and they're kind of big.
Not this one.
Not our one.
Varying size, yeah.
So
Not
it's
this
more,
one.
it's more like a hot tub, okay.
It's,
So it'll
yes,
be up in the air.
without jets and all of that.
Let's put it this way, I'm not sure that we can fit the entire group,
No.
It's not the marsh society won't fit.
Yeah. We can't have a pool
It's gonna be
party.
some crowd.
But, no, in all honesty, I understand, the issue, I just don't see any jurisdiction to regulate.
And I was gonna, that's
In a
exactly where I was
conforming
going.
setback.
We don't have a whole lot of jurisdiction, we don't have jurisdiction saying, what they can do with the setbacks. Like he said, we can't tell them that, no, you can't build on that other lot. It's permissible by zoning, it's permissible by everything. We can't
No,
restrict that.
right, I mean, we were just making because it is really.
As a neighbor,
Yeah.
you can go talk to your neighbor and say, hey, what do you think of this idea? But we can't do that.
Like, in other words, I'm sure if the neighborhood wanted to get together and raise funds, and pay the Schechters for the space and then dedicate it to open space, I'm sure the Schechters would listen. So these are things that are
It's not
definitely.
just about money.
Well, you gotta-
It's real, I mean, it's
Right.
that rim of the
Yes,
marsh,
yes.
there's very few buildings on it. So it is returning to nature all by itself.
So,
I think a big part of this is, I think, the town as a whole is, happy to see a project like this for once.
Well, we are too, and we'd
Yeah.
like to see that land
Yeah.
remain as part of the marsh. That would be wonderful.
Just a structural question, this is all on piers, correct? All the addition?
yes,
I mean, there's a deck now that's elevated.
Yes.
It's on pilings.
Oh, right.
And the deck will be extended with the plunge pool and the structure's 1 story on basically the same level as the deck.
yes.
Just a screened-in porch, and the pool will be completely hidden, the part that's above, that dips down by white grass, just like the rest of it.
The addition of the screened-in porch?
No, the pool plunge area?
No, not the pool, will not be, but
The plunge
the
pool,
structure that's being built.
But
is-
still within the setbacks.
Is it replacing any of the existing things that are on the piles?
Yes, it's coming out on the pile.
that's not replacing, it's an extension
An
of.
extension.
So
an
you're
extension of
adding
the
more
deck.
piles?
No,
Yeah,
No.
There's a piling plan that's filed with the Conservation Commission. It's
Sure,
available
I
for that. The point of this application is that in order to meet the criteria of the special permit in the floodplain, we need to meet three criteria. We can't change or alter the water course. We have to meet the FEMA compliance or the building code compliance, and
National Flood Insurance Program.
Yeah, exactly. And then I don't
So the
remember.
50-foot buffer is really a conservation commission issue, not you guys.
Yes.
Right, because everything is in the 50-foot buffer.
Yes. Anything else from the audience? You're done. Yes, you're good?
Me?
Yes, you, yeah.
Are you good? I'm done.
Sorry, yeah, you're on. So, sir.
Yeah. I'm Joe Malone. I live across the street at 142 Jericho Road. And I want to commend the Schechters for what they're doing. They're expending a lot of money, a lot of time, a lot of effort. And that's right within the sight line of our property. And it's decrepit. It is, I think, not only an eyesore, but it's a danger to kids who potentially could go over there and, with it falling apart and end up injuring themselves. So, I think at the next Labor Day parade, they should be the grand marshals for doing it. It's a prestigious award. But thank you to the Schechters.
All right. Board, anything else? Anybody else in the audience? Anybody online? Seeing no hands raised, I will accept the motion.
I make a motion on the second application of Jeffrey and Cynthia Schechter, 133 Jericho Road and 10 Meadow Road in Scituate, who seek the relief to allow the construction of addition to a dwelling building at 143 Jericho Road and to raise the building at 10 Meadow Road. The special permit pursuant to zoning bylaws section 476F, and a finding pursuant to section 810.2C, proposed modification of the pre-existing non-conforming building on the pre-existing non-conforming lot is not substantially more detrimental to the neighborhood, and any other relief that the board may grant. And that the board find such raising in addition per the plan of Grady Consulting dating July 14, 2025. It's not creating any new non-conformities to the extent that it intensifies an existing non-conformity. Such intensification is not substantially more detrimental to the neighborhood.
Outstanding. Do I have a second?
Second.
All in favor?
Aye.
Thank you.
Jeff, you write that one?
Yeah, I'll write that one. Thank you. Get it right here.
Hold on a second.
Mr. Karsha, do you want to take the virtual hands? Yes.
Yes, now I will.
All right, 1 second here. If you're dialing in by phone, you end in 566. You should be able to unmute just your name, address, and go ahead with your comment. Thank you. One more time to unmute. If you're on your phone, push *6.
So here.
Yep, go
Can
ahead.
you hear me?
You are unmuted. Just your name, address, and go ahead with your comment. Thank you so much.
Mary Patterson Lund. I own 4 Meadow Road. I own 166 Turner Road. I own 166 Turner Road rear. I own 0 Scituate Ave, all abutting the marshland in the Sand Hills. Just to start off, there's a little, the story's wasn't quite told as it played out. There was a meeting, it was before conservation. It was brought before conservation by Frank Snow. We all know Frank is the chair of conservation. Frank Snow came in, my daughter had a open line of communication and proposals with Larry Mayo, lawyer in town, Sue DePisa, Jack Conway, and I can go down the list of everybody else who's within the town hall that was well aware. She had offers up to $350,000, and they kept saying, can you go higher? Can you go higher? The whole time we were going higher. Now, you got to remember, my father gave 52 consecutive years to this town. My brother gave consecutive years as the harbor master. We have generations, and I know, as you do or do not know, Cindy, who is the wife and the applicant, is the daughter of Scott Roberts, who was the chair of Conservation Scituate before. Frank Snow.
Do you have a question? Do you have a question?
All right. My question is they said that house has been abandoned and no one has touched it, no one has done anything. That's not true. For 6 years, Craig Valdez came before Amy and the board, multiple boards, and he wasn't allowed to cut the grass. So as far as no one as it being abandoned, it was not. Second, like I said, she had offers in on that house. Third, like I said, like even right now, the gentleman in the white shirt that's representing, I don't know what he's representing, but he just came across private property and trespassed. And I had to go out and tell him that Penn Meadow Road is landlocked. You cannot exit it or access it by the marsh side.
Ma'am, do you have a question regarding 10 Meadow Road?
Yes, I do. Yes, I do.
What is the question? What is the question?
Okay. Today, the 21st, I just received a letter from Town of Scituate Conservation sent to me by a Grady surveying company out of Kingston. It's the first time that anyone has mentioned a pool like going in. And believe me, as you said, talk to your neighbors. I went over, I spoke with Jeff. Jeff and I had a conversation. Jeff told me he was a man of his word, a lawyer. He would put it in writing. He was never going to build on 10 Meadow Road. It would be open green space, but he never mentioned to me that there was a pool going in. This letter that I received today talks about, it talks about moving fill and bringing in fill and moving, that's not going to. Go ahead.
I understand you're concerned. I don't understand your question, but
you're giving him approval to fill area subject.
They're doing a hot tub. They're doing a large hot tub on a deck.
Okay.
On 143 Jericho.
143 or 10? Okay, so none of that is going to come. None of that's going to come into the property of 10 Meadow Road.
Correct.
Mary.
You understand, when we take on water in any one of these northeast storms, my house, never mind every one of my houses, like I said, I have 4 properties. We sit in 12 feet of water for weeks. So where is the fill going? And where is the dredging going? And where is the plans? Where is the alterations?
The only activity that's being proposed on 10 Meadow Road, the lot that you know as 10 Meadow Road, is the removal of the home.
My brother's house. That was my brother and my father's house, yes.
And it's no longer. So
yeah,
that's the only activity that this application proposes on that lot. There will be a conservation application, which you did just receive in the mail notice of, that talks about the specific land alteration that's required for that type of activity. But that's not before this board. What is being proposed is the removal of the building from that lot, which is 10 Meadow Road, such that there's no building on that lot. Is there still gonna be a shed on the lot?
There's a shed across from it, which we would propose to remove as well.
Okay, so there will be nothing on that lot. That's what is being proposed.
Are they going to elevate
Are they
going to elevate that lot?
No, there's no fill being proposed.
Well, they said you spoke of giving them permission to bring in fill to make the 2 lots, separate lots, 143 and 10 Meadow, level.
If I said that, I was mistaken, but I definitely did not say that because it's not being proposed. So
all right, because you did say the 2 separate lots would be merged by bringing in and making them a level,
If you say I said it, I believe you, but what I'm clearly saying right now is I'm not, is that activity that you heard out of my lips is not happening.
Because any elevation is just going to put more water into my house.
Yes.
Yeah.
That's quite possible, but we're not proposing any elevation.
Okay, and I mean, totally separate, but until they start, upgrading the brook and opening up the brook so the water flow goes out, the water is just there for weeks. And we're stuck here.
That is a matter that is beyond the scope of this board and this hearing. I thank you.
All right, well, I just want you to know where I'm coming from.
I understand. I thank you for your call.
I've lived here for 65 years. Please don't be disrespectful.
Thank you, ma'am.
I think they hung up on me. Just so that, like I said, I want notifications and I want to know what's going on in my backyard.
You will receive all the proper notification. Thank you.
I appreciate it. Thank you.
Mr. Parsha, you have no other hands raised.
Thank you, Jeff.
Jeff, thank you.
You're welcome, thank you, we appreciate
Thank you
all
very
right,
much.
that decision, appreciate it.
So the next week.
Jeff.
Oh. Very good. On our next item of business, Stockbridge Landing, zoning board of appeals votes to approve, we need a vote to approve the as-built site drawings for Stockbridge Landing 40B development per condition 45 of the comprehensive permit signed by the board and filed with the town clerk and planning board September 16th, 2016. As-built approval shall not be considered complete until the as-built vote of the ZBA and all surviving conditions have been filed at the Plymouth Registry of Deeds and/or land court. Bob.
This is basically a pro forma condition of a 40B and would be in any 40B, not just Stockbridge Landing. We've had the plans reviewed actually multiple times by the town's engineer for the project, Merrill, and they have been approved in their final form. So by the engineering firm that was retained to oversee this project. So I would recommend the board vote in the affirmative and it will officially close out the project.
Any questions from the board?
No.
Well, good, so for the uninitiated, what's the background, I don't, what are we doing?
Stop.
Let me go back a few years. Actually, you'd have to start the Stockbridge Landing story, you'd have to go back, I think, about 15 years. So it's gone through several iterations, but it's a development of 68 units in 34 duplex buildings off of Stockbridge Road, actually kind of right across from where Chris lives. You ought to go in there, they did a really nice job. For a 40B development, affordable housing, 25% of the units are affordable.
It's a nice little development.
It's pretty sweet, it really is.
Does something that we have to vote to approve the final plan?
This is, yes, the site plan showing utilities, the roadways, construction issues of the site. The building plans have all been approved by the building department and given occupancy permits, and that includes the as-built foundation plan. So each individual parcel that one of these units is on, that's already been approved. This approval is for, the entire site development, roadways, drainage, protection ponds, that sort of thing.
It's already built?
Yes.
Yeah, so it's already built.
Yes.
Bob and I, as soon as I saw this, because my first, hearing of this. So they've reviewed the plans with engineering. They've gone through when they approved that subdivision, there was a list of conditions.
Okay.
They've gone through the list of conditions and everything, they've checked all the boxes. This is the last box they have to check. So the engineer, Grady was the engineer? Yeah,
Yeah.
So they've spoken with Grady, they've gone through the plans, Grady has drawn a final plan, what it looks like now, with all the details and all that. This is a, like I said, pro forma.
This is just accepting.
We're accepting
This
this is done.
It's already approved.
Yeah.
I make a motion to vote to approve the as-built site drawing for Stockbridge Landing 40B development.
Any seconds?
Second.
All in favor?
Aye.
Any opposed?
Proposing adjourn the meeting? I make a motion
You
to
can make me
adjourn.
vote to it? I
Make a motion to adjourn. Make a motion to adjourn.
And it's I second. All in favor?
Aye.
Meeting